Welcome to EPG Pathshala. This is the Philosophy of Law paper, module Free Speech, Philosophy, Law, and AIB Knockout. The objectives of this module are to discuss the main philosophical approaches to free speech and a specific case of the AIB Knockout event. This module was written by Garima Goswami, an independent research scholar in New Delhi. I'm Akash Singh Rathore, a professor at the Lewis University in Rome. Does the right to freedom of expression give us the right to unregulated expression? Does it allow us to speak freely, and should it be so? What have prominent philosophers said about the freedom of expression? What does the law say about the freedom of expression? This module will present some arguments for free speech and discuss the All India Bakjod AIB knockout event, whose organizers are now facing criminal charges. When we think about the history of philosophy in relation to what certain prominent thinkers have said about free speech, one of the foremost or foundational documents is a small book called the Areopagitica, written by John Milton. It's actually a poet and not necessarily a philosopher. Milton wrote this small treatise in response to a licensing order that was issued by the British government in 1643, which banned the publication of books that were considered to be defamatory to religion and government. What was problematic, according to Milton, about this licensing order was that it banned the books prior to their publication. It put the authors who had written books into an extremely complicated circumstance of having to seek various kinds of permissions from various departments of government before they were granted permission to publish. Milton argued that there should be no ban on books prior to publication because there's a great danger in what's called prior restraint. That is, restraining speech even before it is said, or in this case, restraining an author from publishing a book even before that book is published. Prior restraint has its own problems. In Milton's view, the book should be allowed to be published in the first place, and if then it is found guilty of treasonous, slanderous, or blasphemous material, it would be acceptable to attempt to ban it. But to restrain people from being able to say what they intend to say prior to saying it was highly problematic in Milton's eyes. In the United States, the First Amendment to the Constitution is the expression of free speech. It states that Congress shall make no law restricting freedom of expression. And the interpretation of that constitutional amendment by the Supreme Court has been quite decisively influenced by Milton's position. So within the United States, history of cases regarding freedom of expression, the doctrine of prior restraint has been rejected. There are at least 4 very important Supreme Court cases that lay down the law in the United States that if a book is to be banned, it cannot be banned prior to its publication. The New York Times versus Sullivan is one that's most important and has been cited in numerous Indian Supreme Court cases as well. After Milton, another philosopher who wrote a text that was quite relevant to the way that we think about free speech was John Locke in his letter concerning toleration. Now, Locke's letter concerning toleration is not actually about free speech. It's more about the freedom of religion and what a government can do to either restrict or promote religion. That is, to coerce people either in what they should believe or what they may not believe. In this letter concerning toleration, Locke argues that governments must not coerce individuals to follow a certain religion. The choice of religion must always be free and voluntary, but there are certain restrictions. Just as Milton had permitted the restrictions concerning blasphemy and sedition, Locke argues that given that we live together in political society, while one has the right to believe, and we make an analogy from there to free speech, or to say what one thinks or what's in one's conscience, nevertheless we must be tolerant, show toleration in our attitude, in our expression, in our beliefs. So for Locke, the real constraint upon free speech is that it must be articulated with a principle of toleration governing what is said, where it's said, and how it is said. So we take from Locke's letter concerning toleration both a strong advocacy for free speech, and certainly Locke, like Milton, would not advocate prior restraint. At the same time, as in Milton, certain conditions by which we can understand the regulation of free speech. The French philosopher Voltaire is often quoted as saying, "I disagree with what you say, but I will defend to the death your right to say it." This is one of the strongest articulations, not only of free speech, but even speech that one finds objectionable or running contrary to your own beliefs. This adds a new level of understanding after Milton and Locke in terms of whether speech should be free and what conditions need to be met in order to limit it. Voltaire goes farther and argues that not only must speech be free, but even if it is offensive, I may feel offended by it, but I have an obligation to fight for your freedom to say it. The funny thing is that Voltaire never actually said this. This is attributed to him, but what he really said is still a question for historians to argue about. There have been several books trying to discover what it is that he said. What we know is the context in which he said something like this. There was a case of another philosopher, Voltaire's colleague, who published a book more or less systematically disagreeing with everything Voltaire had ever said. And the prominence of Voltaire within French society at that time moved many people to want to censor or prohibit that author from publishing that book, contrary to Voltaire. But Voltaire, in full expression of this liberal, free attitude towards speech, argued that he would fight to the death the right of that author even to insult his own thoughts and beliefs. The fourth philosopher that we can mention is John Stuart Mill, whose On Liberty takes up free speech very specifically. According to Mill's argument, no society is completely free if certain kinds of liberties are not respected. So just as we see in the United States Constitution that the freedom of expression becomes the number one article within the Bill of Rights, Mill believes that freedom of expression is more or less the litmus test for whether a society is free or not. If you cannot say what you feel, and if you have no right to your own beliefs, then you do not live in a free society. Freedom of thought, feelings, opinions, and sentiment is crucial to living in a free political society. However, Mill also permits certain kinds of constraints on the freedom of expression, and that the main constraint is known as Mill's harm principle. So if the way in which one expresses oneself, the content of that expression, does harm to another, then this speech must be limited. And the limitation of that speech is not in violation of our fundamental freedom. So what we see in Mill is the beginning of the very contemporary way of dealing with free speech, which is to say that we balance free speech, which is a fundamental right, with certain other rights of other persons within political society. I have the right to say what I will, but I do not have the right to harm you. And therefore, the extent or the scope of my freedom of speech is limited only by the harm that you may suffer as a consequence to it. Mill's argument is more thorough and philosophical, and it's quite interesting because many authors, such as Akhil Bilgrami and Neeraj Chandok, have written extensively about the way that Gandhi's thought is in many ways similar to Mill's thought on liberty. What Mill says is that the silencing of any opinion is actually illegitimate and harmful to society. So if we are to restrict the speech of a person, we have to realize that we are not just limiting the freedom of a person, we're actually taking away something from society. What is it that we're taking away from society? Well, we're robbing society of the possibility of hearing alternative points of view. Now, what I say might be true and it might be false. So the obvious retort to Mill would be, sure, we shouldn't rob society of the possibility of hearing true things, but obviously we can prohibit false speech. Now this is tricky because who's to decide what is false in the first place? And secondly, as we saw in earlier authors like Milton and Locke, a lot of what was considered to be false was other religions to your own. So Mill has a twofold argument against that counter-argument. He says that even if what I say is false, you're still robbing society of something. What are you robbing society of then if we restrict false speech? Well, you're robbing the person who hears that false speech of the possibility to trigger his rationality, his reason, and come up with arguments against that speech. So you can keep in mind a very classical understanding of the role of reason and speech in terms of human capacities. As you would have learned in basic philosophy courses on Aristotle, Aristotle had been known to define man as the rational animal. The words that Aristotle actually uses are the animal, the zoon, that has speech, logos. That word logos was later translated into ratio in Latin, and it became known as man is the rational animal. But as the philosopher Hannah Arendt has argued, the better translation for Aristotle's phrase is man is the animal that engages in discursive practices, in speech. Mill is taking up something of that when he says, why should we restrict false arguments? You're robbing people of the chance of expressing their reason, engaging in discursive practices. And this is very important to a free and robust political society. So on the one hand, if the truth is not open to question, then we're robbing society from the chance of hearing the truth. And on the other hand, if we even think that the speech that's expressed is false, we're robbing people of the chance of exercising their reason in disproving that truth claim. We can move on now from these philosophical positions on free speech, both on the defense of free speech and on the conditions of how we can limit it, to the way that free speech exists and is protected in the Indian Constitution. I've mentioned in the United States Constitution that free speech is Article 1 of the amendments. Within the Indian Constitution, it appears as Article 19, both 19.1, which grants free speech, and 19.2, which imposes certain limitations. So interestingly, the form that the law of free speech takes is identical to the way that philosophers have always argued about it, that freedom of speech should be there, 19.1, but there are some reasonable limitations on that speech, 19.2. In the philosophers we discussed, those limitations would be harm, blasphemy, sedition, and so on. Let's see what the Indian Constitution says about free speech and the limitations that may be imposed. Article 19.1 states that all citizens have a fundamental right to freedom of speech and expression. And the judiciary, the Indian Supreme Court in particular, has robustly upheld this fundamental right. However, there are, of course, limitations. Article 19.2 lays out those limitations. I quote, "Nothing in subclause A of, in other words, 19.1, shall affect the operation of any existing law or prevent the state from making any law, insofar as such law imposes reasonable restrictions," and that's a key word, reasonable restrictions, "on the exercise of the right conferred by the said subclause in the interests of the sovereignty and integrity of India." So here we see the first possibility of restriction, which is that free speech is guaranteed unless we have to protect the sovereignty and integrity of India. Second, the security of the state. Third, friendly relations with foreign states. Fourth, public order, decency, or morality, or in relation to contempt of court, defamation, or incitement to an offense. Many of these limitations express the very same ideas of the philosophers that had been mentioned earlier. So we see decency or morality, incitement to an offense, this is similar to harm, blasphemy, public order. So the limitations that were suggested by philosophers have indeed been taken up, and the limitations go quite further. For example, I think India is the only constitution in the world to limit the right of its citizens to speak freely according to its understanding of friendly relations with foreign states. I'm not sure why this is in the Constitution. Thankfully, it has never been a subject of grounding the limitation of a person's free speech. That's what Indian law says. Let's see a case where it has to be applied, both in terms of the freedom of expression as well as in terms of the so-called reasonable limitations. This case is the AIB Knockout Roast Show. This was a comedy show that managed to bring together a number of adults, not minors, all legal adults, to get on stage and make fun of one another, to roast certain actors and prominent people, and basically to make fun of all of the people who are on stage and their friends and so on. The roast was uploaded onto YouTube, at which moment it became available to the public at large. And as a consequence of that, it had an effect on a number of people. The question is, was it a harmful effect? Was it a blasphemous effect? And were the content expressed in this knockout show in violation of the reasonable restraints that we put on people's speech? Well, they made a number of jokes about Christianity. They made some jokes about the Parsi community, several jokes about homosexuality, masturbation, promiscuity, the academic failure of certain Bollywood stars, the lack of general knowledge of certain Bollywood stars who were present there and laughing, of course. They made some sexist jokes and some jokes that appeared to be racist. Well, about the jokes that offended the religious community, the organizers of the event issued an unconditional apology. This is clearly inappropriate and unacceptable, and also in violation of the law. So an apology was immediately issued to the Christian community, and it was clarified that they did not mean in any way to be offensive or to offend the religious sentiments of that community. Nevertheless, some people filed an FIR in Bombay against the organizers of this event, against the Bollywood actors and the personalities who form the AIB group. These people who lodged the FIR admitted in several instances that they didn't watch the video, that they just knew that it was offensive. Others said they tried to watch the video, but it was so offensive that they couldn't continue to watch it. What was suggested in the FIR was that the content of the event was in violation of Indian norms of decency, Indian culture, Indian morality. Now, who's to define what that is? This is a question, of course, that the courts will have to negotiate. Within Article 19.2, there are prohibitions against speech that is indecent and that violates certain moral norms. But those are not specifically spelled out in the Constitution, although there are laws within the Indian Penal Code that give a more definite description of what it is that constitutes immoral or violative behavior. So the charges against the AIB group were lodged with reference to the Indian Penal Code. That is Section 292, prohibiting obscene content, Section 294, prohibiting obscene acts or songs, and Section 509, prohibiting words or gestures made with the intent to insult the modesty of women. There are other acts and sections of the IPC that were also alleged to be violated. Now, how can the AIB group use both the freedoms guaranteed in the Indian Constitution and the articulation about freedom of expression that we find derived from the philosophers that we discussed? Well, as I had mentioned, everybody involved was consenting. Each person on stage, each person that was making the jokes or was the butt of the jokes consented to be made fun of. Moreover, prior to the video playing on YouTube, a warning ran that many people would find the content of this video offensive, and that if you are the sort of person who is either easily offended or even difficultly offended, they suggest that you do not watch the video because there will be a great deal of vulgarity, buffoonery, and so on. Also, obviously, the unconditional apology that the AIB group made to the Christian community will now remove them from the possibility of prosecution under the sections that prohibit insulting a religious community. Finally, the law stated that obscene content is what is prohibited. But is this content obscene, and who decides? There's a possibility that this content would be regarded as vulgar as opposed to obscene. What is the difference between obscene and vulgar? This is, of course, something that the court will have to decide. What's going on with this AIB event? Why is this an important case for us to consider in relation to free speech? What we see here is a practical experiment of unregulated freedom of expression. Obviously, there was no prior restraint. They were free to upload it. So that is not violated in this respect. But what comes into play is, have they committed a harm? Have they expressed views that subject them to the limitations on freedom of expression that are articulated in the Constitution? Were they blasphemous? Were they obscene? Did they insult morality, and so on? So looking at this case, an unresolved case, because the case still stands in the courts as of this date, looking at this case forces us to think through the philosophy behind freedom of expression and how much freedom we think is legitimate, how we think about this philosophically, and what should be the repercussions politically of a philosophical point of view about the freedom of speech. One thing that we should mention is that the claim that the show violates the Indian moral temperament or Indian culture is not necessarily a legal claim. This is a moral claim and a subjective claim. There are obviously numerous alternatives within the Indian traditions that allow for more inciting or risque kinds of articulations. The AIB knockout community had mentioned that not only were they inspired by the American-style roast, which many people have argued is in violation of Indian cultural norms, but also certain kinds of roasts or poetic gatherings that were indigenous to Indian traditions, where jokes would be made between poets about one another. Who's the better poet? Who's the alcoholic? Who is the lecherous person? And so on. So the very idea of roast can't necessarily be attributed to being just American obscenity. In conclusion, while the AIB knockout might not be protected in the Indian Constitution, it's still open to question. And it might be subject to reasonable restrictions. From the point of view of interpreting what Mill had to say, certainly the activities of this AIB group represents a liberty that should not be interfered with unless it is absolutely necessary. Considering Mill's argument, when we restrict, we don't just interfere with the freedom of the group that is speaking, but we rob society as a whole of something that may be beneficial. Even if seen as vulgar, it could have certain salutary effects. In other words, in forcing people to rise up and consider what is the difference between obscene and vulgar. Without something challenging those borders, we would not have the opportunity to raise those issues. To sum up, while legal prosecution is underway, social prosecution is significant too. The show represents thoughts in defense of absolute freedom of speech. Does our society agree with absolute freedom of speech? Should it? These are questions that the philosopher of law has to consider. AIB knockout is one case of unregulated free speech, and by examining it and the consequences of that unregulated free speech, we get some insight into both the philosophy of law and the ways in which this philosophy plays out in the legal and political sphere. Thank you.